What's up, everybody? It's quite a wild ride. I just had to restart everything and I almost didn't have my Scarlett mic on. Can you guys hear me? Hopefully you can, because I did get it switched just in time. Everything seems to be working. And today we're talking about Brian Kohberger. And like I said last week, it kind of worked out because we didn't do a live last week. We did a static video that I recorded and played. So I wasn't able to answer your questions if you had any around this process and everything that's going on and all of the updates, the body cam footage that was mostly a bunch of nothing burgers. But this gag order stuff could make a difference and it could project to something meaningful in the future. So it's going to be one of those videos where we talk about society a little bit, and how it affects the law and how social media and public interest and streaming and YouTube and all the stuff that we all take part in together, how it can be affected by this process. And I actually think we can learn a lot and discuss the importance of how we act, because we do make a difference, how we speak about this stuff, how we talk about it around, the water cooler, as they say, and discuss it together with our friends and family and have legitimate questions, want legitimate justice, but want it to be done the right way and want to, I don't know if take part in it is the right way to say it, but to be involved and to see behind the curtain and not to be a hidden process, a private process, a process that we can't affect with our votes and things that we do. That's all really important. So we are going to be talking a lot about that today as we dig into a couple legal documents that they do have some spice, John. They do. They really do, because there are shots being taken at the media, which is an easy target. I don't necessarily have a problem with somebody taking shots at the media, but I do want it to be appropriate. And in this case, it's not just mainstream media, where a lot of people have a problem with how mainstream media does things. In this case, the media also at least just a little bit represents us and our rights and our freedom of speech and to take part in the legal system in an open judicial system. So hit that like button if you haven't already. Subscribe to our page if you haven't already. Do all those things. We have a really fun members only video that we're planning for May. That's going to be totally different, unlike anything we've ever done. I hope we can get it done in May if John can come down here to help us knock it out. If we do get it done, I will tease it a little bit more and talk a little bit more. But at the very worst, it's going to be coming in June, and we'll do more of a normal one in May. Some fun stuff like that coming on. More cases coming up. I thought it would be a slow week, but Kohberger ended last week with a bang. So that's what we're going to talk about today, jumping in and discussing his lawyer objecting to the motion to reconsider filed by the media, basically saying, we talked about this in last week's update, but basically saying irreparable harm. We're not knowing what's going on in this case. This gag order is too much. It's too restrictive. The victims and their lawyers can't necessarily even take part in this process. They have a right to, they should be able to, and it is just totally unfair. And we've got to do it now. The longer we wait, if we wait just to schedule something, we're going to have the preliminary hearing upon us, and we're already going to miss out on knowing what's going on, which is essential to fair proceedings and public proceedings. So this is what Brian Kohberger, at least through his attorney, has to say about that. Brian C. Kohberger, Brian through his attorney, J. Weston Logsdon, Chief Deputy Litigation, and hereby objects to the motion to reconsider the order dated May 4th, 2023 on the grounds that the media's motion to vacate the amended non-dissemination order raises factual issues that Mr. Kohberger requires additional time to prepare. I like how he just says motion to vacate, not or amend. The media argues in its motion that it is irreparably, quote unquote, harmed each day this court's amended dissemination order remains in place. In essence, the media argues that this court should grant a temporary injunction against its own injunction. It's kind of funny when you put it that way. It claims that this was the intent of the Supreme Court because it moved quickly to determine that its petition for a writ was filed in the wrong forum and using the wrong vehicle. So here's where I will disagree a little bit with Kohberger's attorney. I don't think they were saying that the court should grant it just because of what the Supreme Court did and how quickly they did it. Okay. I think they're saying, and I think the media argued, this is supposed to be a timely remedy. So if you're not going to give us a timely remedy, we think you're not listening to the Supreme Court. Now, as I said all along, this magistrate could hold a hearing, deny the media's motion, and do their job and provide their answer in a speedy way, which is what the Supreme Court said and what the rules allow. And then once they say no, then the media can appeal it up to the Supreme Court and handle it appropriately and take the appropriate vehicle at the appropriate time. So that's what we're talking about. And nothing I'm saying here is going to state that the judge should get rid of this dissemination order, should grant this injunction. All I'm saying is let's do this in a timely manner. And I do think the media was in the right to make a parallel between how quickly the Idaho Supreme Court handled this issue and how slowly this lower court is handling it. Okay. So I think that's important. But Kohberger is basically saying, oh, the media wants this court to file an injunction against their own injunction. And they said the Supreme Court made them to, but that's not really what happened. The Supreme Court just said you filed it in the wrong jurisdiction, which is technically true, but they could have just summarily denied the media's motion and they didn't. They put all that other verbiage in there in dicta, as we call it, to explain why they were denying. It also fails to note that the petition for a writ, let me make this bigger for you. The petition for a writ was a purely legal issue, whereas, as it has repeatedly argued, the basis for the entry or amendment of the non-dissemination order is a question of law and fact. The media seems to be acting on the premise that the order should simply vanish now and that it has arrived on, now that it has arrived on the scene. That's where it's a little spicy. The media is saying this needs to go away now that we have arrived on scene. Instead, this court has reasonably and correctly recognized that the proper path forward is a hearing where the parties may show what evidence there is of prejudice and the potential for prejudice to Mr. Kohberger's 6th and 14th Amendment rights to a fair trial from the removal of the non-dissemination order in this case. So a couple things here to point out. Number one, whenever you can agree with the court as a lawyer, you want to do it loudly and as often as you possibly can in a motion. It's like, Judge, you are so smart and considerate and wise to make this decision in the first place. And we just think you did such a great job balancing all the issues. And if you want to do a great job in taking your time to consider it further as this order that's in my client's favor or what I want for my client is in place, we think you should do that. Anytime you can do that in a motion, do it. That's exactly what you should do. And I don't have any problem with him doing it here. Basically saying you made the right call with the non-dissemination order, Judge, and you made the right call now, making sure justice is served, that we have time to plan accordingly to present our evidence as to why Brian Kohberger's constitutional rights are being affected here. Because the media coverage of this case has been intense, and because Mr. Kohberger plans on providing, this is the bombshell to me, plans on providing expert testimony on its damaging effects, Mr. Kohberger will require additional time and will not be prepared for such a hearing on May 22nd, 2023. So Kohberger, through his lawyer, is saying this needs to be done as a scheduling conference on May 22nd, exactly what the court ordered. Their objection to it is just the media being the media. They lost up at the Supreme Court because they filed it in the wrong jurisdiction. Dummies. He doesn't actually say that, but that's kind of what it feels like. He's like, listen, they lost because they did it wrong. We're lawyers. We should know which route to take and when to take it and what the appropriate remedy is. And they didn't. And they lost. And now they're trying to use that loss as a win to put pressure on you. And that's inappropriate, Judge. You did everything right. We need to use May 22nd as a date to schedule it out because we want to explain to you all the evidence we're going to present, which is going to take time to prepare. And we saw this play out in the Daybell and Vallow case. When one side needs more time to prepare in the interest of justice, the judge should allow them to prepare. But there are times where time is of the essence. We saw it in the Live Golf and PGA Tour case. And that's what's so cool. The longevity of having this YouTube community and all these other cases we've talked about together, and we can reference them. That's how lawyers work. They're like, this happened in this case. This happened in that case. We bring it together, and this is kind of how we're going to apply it to this case. So we're able to do that together, which I think is really cool. So in the Live case and the PGA case, they said, We need an injunction. We need something immediate because we're losing money. We're losing points. We're losing opportunity to play in the majors. We need you to decide right now, judge, whether or not the PGA is allowed to do this. And so there are times where time is of the essence and the judge needs to say, listen, we get you need more time to prepare, but we need to do this now. So it's all about reasonableness and justice. But here is where we're going to get into our philosophical discussion. And by the way, there is a media reply to this objection that we're also going to read together. But first, let's read this last paragraph again together one more time. Because the media coverage of this case has been intense. Intense usually means you guys, the public, and me, and our community here on YouTube. If there's intense media coverage, usually it means we're interested in it. Usually it means we're talking about it. Usually it means we're learning from it. So intense media attention is something we should keep our eye on because that's going to be something that's going to happen in future cases as well. And because Mr. Kohberger plans on providing expert testimony on its damaging effects. So the intense media has damaging effects according to an expert. And in order to flesh that out, Mr. Kohberger needs additional time. Okay? So what does this mean for us going forward? It means that there is a group of experts, or at least one expert forming to discuss the negative effects on intense media attention. And while this is nothing new, and this has happened in other cases, it's important because this is one of the most intensely covered cases from pre-arrest investigation through the arrest, through the preliminary hearing hasn't even happened yet, let alone a trial. Now, we've had Murdoch and Lori Vallow and Netflix documentaries and HBO series and other cases that have been intensely scrutinized. But this is the entirety of this case is in a post Johnny Depp Amber Heard world. And that's what we talked about. How is this going to change things? Well, this is how. And if there are experts coming together, doing the research, showing the negative effects, what is the outcome of that? The outcome of that is no more streaming, no more audio, no more video, no more open courts to the public at large. Now, the courtroom doors may be open for people in Idaho to come show up if they want to. And I think there's an argument to be made that that is still a public court system. But this could severely affect the ability for the public to actually see what goes on inside the courtroom of criminal and civil cases. Now, how can we affect this? How can we make this not be the outcome? Well, it's pretty simple. Intense media coverage does not have to violate the rights of criminal defendants. Intense media coverage does not have to have damaging effects on Mr. Kohberger's 6th and 14th Amendment rights. That's what's referenced in here. So how can we do that? Well, as we've talked about so much, and anybody that wonders why I harp on this, and I think most of you do too, and I see you on Twitter, and I see you talking to other people in other chats and things like that, talking about constitutional protections in America for those accused of crimes, for criminal defendants. This is why we have to hold the presumption of innocence high. The burden of beyond a reasonable doubt as the highest burden in any American court system. Why scrutinizing and questioning and cross-examining victims and witnesses, or I should say alleged victims and witnesses and pieces of evidence and law enforcement, why that is part of the process. Because we've seen, and I'm not talking about this case, right? We're talking about cases at large. Because obviously the victims are legit victims of this case. Now, are they victims of Brian Kohberger? We don't know that yet, but they're absolutely victims of a crime. There are other cases where people just lie about being a victim, whether it's civil or criminal. We've seen that in multiple ways just in the last few years in televised cases. But that's why it's so important, because if we do protect those rights, if we do presume them innocent, if we do say, well, let's see if they can prove it beyond a reasonable doubt. Let's see if law enforcement did everything right. Let's see if these witnesses are telling the truth, if they're corroborated by evidence. If that's the case, and that's how we talk about it before the case gets to trial, then even intense media coverage or intense public interest will not have damaging effects on the constitutional rights of criminal defendants. So we all have to be very careful about how we discuss these topics and how we discuss these cases as to not take away people's rights or trample on people's rights, especially to the effect that experts are going to come in and say, well, look, they're taking these voting polls. How many people think Brian Kohberger is guilty? Well, 99%. Look, this is the public at large. Look, these are people that watch in Idaho, and they can probably see which of you watch in Idaho and which of you click guilty. And therefore, that can affect the jury pool. And the jury pool is being poisoned with this media attention. Now, I'm not saying that's true, and I'm not saying that's really how it is, but we need to try to take away the opportunities of people to say that by acting appropriately and thinking appropriately about this case, not condemning people, not convicting people in the court of public opinion before we see any legitimate evidence that passes the muster and the rules of evidence and the constitutional protections. That is what's really, really important. Because if we do create a society where we convict people in the public because we hear one side of the story or we hear one news station spin it a certain way, then it's over. And we don't deserve to hear about this stuff or talk about this stuff, because while some people may just be interested to see how the system works or learn about it, it's not worth it to educate anybody about the system if we are taking away rights of people, affecting their lives, putting them in prison for life because we're not giving them a fair shake. We don't ever want to create that system. And so Brian Kohberger plans to present evidence from an expert as to exactly that. This intense media attention and public interest is damaging and prejudicial to Brian Kohberger. Now, let's take a look at the media's response. All right, reply to Mr. Kohberger's objection dated May 11th. Mr. Kohberger's objection to intervener's motion to reconsider order dated May 4th, 2023 highlights the exact problem here. Okay, the media is like, haha, I got you back. You come at us and say we arrive on scene and immediately want things to go our way, or that we're misrepresenting what the Idaho Supreme Court said. Well, you, on the other hand, have just proven our point for us. He requested and received a gag order without submitting supporting evidence to the court. So what do they mean here? I realized it was small. I will make it big here in a second. So the media says, look what you just admitted, Mr. Attorney for Kohberger. You're saying you have evidence now to prove the necessity of a gag order, which is fine. If you want the gag order and you present evidence and the judge decides to give it, fine. But look what happened here. You didn't even have to present any evidence for this court to order an overly restrictive gag order. And it's an interesting point. It's like me saying to my brother, you don't even have to go ask mom. She's always going to side with you. And I go up and my mom says, oh, you know, little Johnny instead, we're going to do what Johnny wants to do. And it's like, Johnny didn't even ask you. And Johnny comes up and he's like, what? It's like, there, you just proved my point. He didn't even have to ask. So they didn't even have to present evidence to get this gag order, which I think is interesting. He says he now has evidence to support his request for a gag order, but he needs time to put it together, even though a gag order has been in place for over 4 months. And he asked the court to continue to enforce a gag order while he collects his evidence. That is what they're saying. Mr. Kohberger's request turns the judicial process on its head. When a party requests a court order, he has the burden of submitting the evidence that supports that order before the court issues the order. A party is not entitled to obtain relief first and then take months to collect and present evidence that purportedly supports the request for relief. Now, what's interesting about this is it wasn't just Kohberger asking for this gag order. The court felt it was necessary. The state and Kohberger agreed, and it kind of was a team effort. Things happened in chambers that we don't know about. A lot has happened that's been sealed and then unsealed. So I don't think this is necessarily fair that it was Kohberger that was just on a mission to get this gag order, but it makes sense what they're arguing. While those principles apply generally to the judicial process, they are paramount when the unsupported court order restricts First Amendment rights. The loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. Interveners have suffered irreparable harm to their constitutional rights since January. The judicial process, including the expectation that a party submits evidence before obtaining relief, particularly relief that affects another party, is designed to prevent that irreparable harm. As Mr. Kohberger now acknowledges, that process was not followed here, as he still has not even collected the evidence he intends to submit. So another thing that's kind of unfair about this representation by the media, just keeping it real with you guys, keeping it 100 as we always do. This does not, Kohberger's lawyer did not say this is the only piece of evidence we ever presented to the court. It does not say that we haven't presented any evidence to the court, because they could have presented other evidence. Maybe just not this specific expert on this specific topic presenting it in this specific way. He did not say the only piece of evidence we've ever had is something that we're still putting together to tell the court. So I do think that's a little bit of an unfair characterization by the media, but these are the spicy shots they're kind of taking back and forth that if I was a judge, I'd be annoyed with, and I'd be like, guys, come on. Let's try to do this a little more professionally. As interveners have requested, the court should stay enforcement of the amended non-dissemination order pending any further briefing or hearing on interveners' motion to intervene and motion to vacate the amended non-dissemination order to avoid any additional irreparable harm in the interim. If indeed an evidentiary hearing is the next step to determine whether a gag order is needed, no gag order should be enforced in advance of that hearing. And again, this happens all the time where there is a temporary injunction in place until you get a permanent injunction. Things like that happen all the time. So here's what I would do. I think this is kind of a simple answer, not to say that I think this is what the judge is actually going to do, because it seems like she's not based on her other actions. But to me, this is pretty simple. I see arguments, in case you haven't noticed, on both sides. But what I definitely feel is necessary is to move this as quickly as possible, as quickly as justice will allow. It has been months since this gag order was in place, and I'm not going to stay it or put it on pause or take it away until we have a hearing. Although the media makes a good point. I bet you if I put the gag order on pause and open the floodgates, Kohberger's team and the state would be ready very quickly in order that they are not irreparably harmed with evidence leaking that could be damaging to their client and their client's constitutional rights. So that makes sense why you'd want to pause the stay, although I wouldn't do that. That's number one. Number two, I know for a fact as a judge, because there are scheduling issues and things like that, I know for a fact everybody is available on May 22nd to come to this scheduling conference. So what I would probably do, and I don't know if neither side would like it, which probably makes it a right decision, I would say May 22nd, we're having the hearing, but it's not a scheduling conference. It's the actual evidentiary hearing for me to decide whether I need to get rid of the gag order, whether I need to amend the gag order, whether I need to clarify the gag order. So everybody bring your evidence, everybody bring your testimony on May 22nd. And what does that do? It limits the irreparable harm done to the media, if any is being done. It provides them a speedy remedy, which the Supreme Court basically directed me to do as a lower court. Number three, it allows Brian Kohberger another week to prepare the expert testimony and evidence to present at this hearing. And while it's not as much time as he would want, it's ample time, in my opinion, to present this evidence. It's not going to be a 3-week trial. He's already had months to gather this. He knew about this on May 4th that we were starting to schedule this. He knew about their objection on May 9th, I think it was, or 10th. So it's at least been weeks. And if he's done nothing, he still has 7 more days to put this together. And we are going to make a decision shortly after that May 22nd hearing. Everybody's going to get to present their evidence. Everybody's going to be heard. And I am going to provide the remedy. Now, I'm not saying who I'm going to rule with. I very well could say the non-dissemination order is staying exactly as it is. And then you can appeal it up to the Idaho Supreme Court and see what they say. Or I could totally get rid of it. You base that off the evidence presented to you at this hearing. So that, I think, is interesting. That's how I would handle it. I'm not a judge, though, so who the heck knows what they're going to do. All right, let's get to some questions. I have seen some questions come through the chat. Is the preliminary hearing still on for June? As far as we know, the answer to that is yes. And that's basically all we can answer at this point, is as far as we know. Christina Rain and Barbara, Mindy C, Sandy Van Eck, welcome to the membership crew, and Sunshine Dragonfly. I'm really looking forward to this members only video. It's a non-law topic. It's one of my other hobbies or loves in life that I have, non-law. Miss Escobar, happy Monday, everyone. Happy belated Mother's Day. I hope everyone had a fantastic day. Max Sauce, hey fam, my Google Play account had fraud and I couldn't buy super chats for almost a year. So glad to be back. Thanks for breaking this down. Max Sauce, we're glad to have you. And I know you've been lurking, you've been around. We've seen you. I've seen you on Twitter, Instagram as well, in the messages and stuff. Appreciate that always. Ellen, did intense scrutiny didn't hurt OJ Simpson, did it? Thanks for all you do, Peter. Depends on what side you're on there, right? Maybe it helped OJ and hurt the victims in that case. Or maybe it did hurt OJ. Maybe the public perception thinking he's guilty now, which I think is kind of what the public perception is, maybe it wouldn't have been that way without that intense scrutiny. Who knows? Point is, we should do our best to not make it have negative or damaging effects. D. Trug. Peter, in your opinion, has the gag order stopped Bryan Kohberger from being tried in the court of public opinion? I agree with a gag order, but the wording is a bit broad, in my opinion. I think a gag order is appropriate, and there's nothing wrong with a gag order. I think it should be limited. I think we should know about the filings. I think we should know about the hearings. I think we should know about what's going on in the case. Do I think we need all of the information about the victims or medical information about Bryan Kohberger? No. I don't think we need to know everything, but I think we need to be at least open to the process of what's going on and how they're moving down, and whether or not they're not going to do the preliminary hearing. I don't know why there's these rumblings of that. That's the type of stuff that's hard to keep track of when there is a gag order in place. Miranda, I'm on the side of the order. It's obviously becoming prejudicial to Bryan Kohberger to have more info out there, especially with places like News Nation being more scummy with their coverage as time goes on. I think that the judge should this would be really hard to litigate and to enforce, but it should almost be like, you can't say he's guilty. You can't say he did it. You can present what's happening without conclusion. I wish we could do it like that. I wish judges could explain to the media that that's how you should present it, and then you're not becoming part of the problem. But I do agree with you that, I'm not going to call out any specific news places, but there are some places that just condemn, convict, it's over. Let's get our pitchforks out before we know anything. And they may be right at the end of the day. I'm not saying they're not. Tori, I fully and wholeheartedly will fight for my rights and the rights of others as long as it doesn't prejudice someone's right to get a fair trial. Glad to be here for Alive. I agree. And if the expert testifies and the judge looks at how the media has covered this case, including some videos that people have mentioned that we've watched on this YouTube channel together, if the judge looks at that and says, yeah, it's already happening, I'm not going to do it, the gag order stays in place exactly how it is, I could understand that, and I would respect the judge's decision. Even though I'm part of the people talking about this case, I would absolutely respect the judge's opinion there if they feel it's going to affect somebody's constitutional rights. Thank you for the super sticker, Azam. Ronell, hi, Peter. With all these defense motions already, what's the chance of this trial not being live streamed? So I will say, I think, unfortunately, there's a high likelihood that this case will not be live streamed. And there's a lot of reasons for that. Okay. Number one, we just saw it in the Daybell or in the Vallow case in Idaho. And I think they felt like they protected the process there. She was convicted. They didn't have a lot of the dramatics. And I think they were probably happy with how that went. Okay, that's number one. Number two, in that case and many other cases, there was not this much of a gag in the pretrial process. Now, there was a major one in Murdoch, which not a lot of people talked about, but then the trial was just live streamed for everybody to see. So that could be something on the other side. But I would say 3, because of the intense media attention and how it's gone so far in this case, that's a pretty big knock on the chances for this case to be live streamed. Just one man's opinion. Angela, correct. Innocent unless proven guilty. Actually, until and unless, because if it's until proven guilty and you're never proven guilty, then you're still innocent. But I get it. I get what you're saying completely, unless you're proven guilty. Helena and Sheila, welcome. John O'Rourke, what are your thoughts on the pretrial documentaries? I hate them if they condemn the person. Like, I mean, the Murdoch murders, the sins of our mother. It's pretty clear what the angle of those documentaries are going to be, right? So I think that that's one of the issues that we're dealing with is if it was a documentary and it's just presenting things for us to think about and to talk about, then that's fine. But if it's pushing the public and it's pushing it out there on HBO and Netflix and some huge, huge platforms, I think they're incredibly problematic. I couldn't believe that Lori Vallow documentary came out before the trial took place and that the Murdoch stuff was coming out right before and during the trial. I mean, to me, that's tough. I don't think that should happen. But can't control that. All right. Let's see what else we have. Velo Ange. So it's up to the judge alone. At this point, yes, it is up to the magistrate that put in the gag order in the first place. It's up to her. But if somebody does not agree with her decision, they can appeal it. Yes, Mellow Wello. Remember to hit that like button. 4,000 of you in here hanging out. Zero said, makes me think of the early days of the press. We need to figure out our professional standards without the law. Hey, that's a good point. You shouldn't need a judge to direct you how to do things professionally with journalistic integrity, right? I agree with you there. I do. But unfortunately, and that's the point. That's why I want our channel and our community to be different. Nobody has to tell us how to talk about it. We should know how to talk about it based on what the rules are and what the laws are. And that's what we're here to discuss and talk through with each other. Balt MV is enjoying her birthday with us, or his, I guess. I can't tell by Balt MV. So happy birthday. Thanks for being here. Yeah, Vicky, maybe I'm wrong, but if I was innocent, I'd want cameras in the courtroom, as did JD. And I think Murdoch did too. I did. Not to say that he's innocent, but I think he thought the case was going to play out well for him on the video. So, and again, we've talked about narcissistic tendencies with certain people and thinking they can talk their way out of issues. So we get it. Jay-Z, hi, Peter. Thanks for the live. Driving from Connecticut back to Texas. Somewhere in Indiana right now. Needed this. Have a great day. Well, thank you, Jay-Z. I'm glad you're here. Drive safe. Correct, Eliza. The Gonsalves family also wants the gag order lifted. And I think they would be cool with some clarification to say, Mr. Gray, the attorney, can comment for the Gonsalves family. The Gonsalves family can comment on this, but not that. Just a little bit, just a little bit more of a clarification. Jessica Sunny, why not respect the privacy of the defendant? In my country, that info is not given out unless someone is on a wanted list. So the process of a criminal defendant going through the defense of his case and the criminal litigation process is open and the courts are supposed to be public. But medical information, private information, family information, personal identifiable information, that is all private. He still does have certain privacy rights, but the charges and the evidence they have against him is not private. That is public because, again, in our country, society and the public and the people are supposed to hold government accountable. Government includes the president, of course. It includes Congress, of course, but it also includes judges, prosecutors, public defenders, other lawyers, law enforcement. It includes all of those people as well, which is why it being public is really important. Oh, okay. So courts are public, but media isn't allowed to publish names. I mean, I think that's something that's possible. Just take it out of the media completely and it be public and like, or be public like on a website, like a public records request, and you can go look it up there. I mean, potentially, but the media is what the media is, right? There is freedom of speech. There is freedom of the press here. And that's really important so that people can see it if they don't have access to those public records or don't have computers or don't have ways to do it. So that's important. Gina Tingley, thanks for the super sticker. Creed M, it should be up to the defendant if they want their trial public. What about the victims? What are their rights in the publicity? Publicity is a bad word, in the public nature of the case. Just interesting, just food for thought. And also, if you think about the other people involved in communities, when we have cases that happen at schools or that happen to certain communities or certain people that represent certain communities, the country does have a public interest. What are we going to do about it? What's law enforcement doing? Did law enforcement handle this properly or improperly? How do we find corrupt judges or corrupt prosecutors and things like that if everything is just not accessible and the media is not allowed? To be fair, let's listen. We call it like we see it here. And the media, in all of their glory, and negativity and what people may say and things like that, they have broken a lot of stories. They have protected people that haven't had a voice without the media. They have shined a light, even if they have their own secondary reasons for it and they benefit and profit from it. The public does too. And they get access to things that we don't get access to. Now, is there corruption? Is there misrepresentation? Is there fake news? Sure. But there is some good in there too. And that's, I don't like to throw out the baby with the bathwater. Is that the saying? You guys know how good I am at sayings. Ali, what are the next trials you're covering? So this is a great time to talk about this, and hit that like button. If you want to be involved in what content we're going to talk about on this channel, just hit that like button and subscribe. That's all we ask. We hit 230. We're going to inch our way towards 250K. That's one of our goals here before the first half of the year is over. So we still have, another month and a half here to try to hit that. But we have our eye on the Courtney Clenny OnlyFans case and Sarah Boone suitcase, murder case, we'll call it. And those are both in my home state of Florida. I know a lot of people involved in those cases. So that's going to be interesting. We're definitely covering those two. We have the Chad Daybell case, which looks like is not going to happen until next year. Kohberger, obviously. Alec Baldwin stuff, we're still keeping our eye on that if anything else happens. But there is some time to potentially pick up a new case or two to my case list here, we'll call it, like I have at my office, and look into it. So if you guys are all interested in similar cases, put it in the chat, put it in the comments, post it on the community page when we look for new suggestions, because you all control the content here. And Charlie Adelson's another one up in Tallahassee that a lot of people have been interested in. The case with the doctor and the murdering the lawyer, or allegedly murdering the lawyer, here in my backyard, literally in Largo. So there's a lot of stuff out there, but I want to hear from you. And I want to pick the cases based on what you guys are most interested in. T Mama. Hello. Welcome to the membership crew. Okay. So that's all we've got today. I appreciate everybody joining me. If anybody's new here, there's always some new people that come in during Kohberger stuff, I feel like, because there is such a public interest on this case. Stick around for the outro to hear about, what we actually do at our firm, real lawyers, handling real cases. I think that makes a big difference in talking about it with you, because I'm in the weeds and in the trenches of writing the civil rules in Florida, talking about the federal rules. Criminal and civil justice is incredibly important to us. We've dedicated our lives to fighting for people in those processes and teaching people and explaining people what their rights are and how the process works. That's what this channel is all about, so that if you don't know a lawyer, now you do. So thanks for joining me today. Hit that like button on the way out. We're done here today. Till tomorrow, see you later. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.